first and the second part of our 2019 Collaborative Law Practice Series. If you're just joining us, I would ask that you please do not put your phone on hold. And I also ask that you please mute your phone. You will have time to ask questions during the presentation. You may enter those in the chat box. And you will be provided with a code at the end of the webinar to enter into your evaluation survey. And you should have received the evaluation link in the email invitation that provided you with the login and dial-in instructions for today's webinar. And now I'd like to turn the webinar over to our panelists. And so, Stephen, I'm going to let you take it away.
Hey, everybody, this is Frances Nolan. Just want to welcome you to our 5th webinar on collaborative law. I would say we are here by popular demand. We had so much response to the first 4 that we've decided to keep the series going. Our topic today is the application of collaborative principles in the mediation process. And I'm going to turn it over to Steve so he can introduce our fabulous guest speaker today.
Thank you, Frances. We're very happy today and honored to have David Hoffman speaking to us in the webinar. You can see the screen. David is the founding member of Boston Law Collaborative, and he mediates and arbitrates and also is a collaborative law attorney. Some of you may know him from his work at Harvard Law School, where he teaches as an adjunct professor in various fields. David was named Boston's Lawyer of the Year for 2016 in the field of mediation. David's practice focuses on resolving conflict in business, family, and employment cases. He served as a mediator and/or arbitrator in more than 2,000 cases of various kinds, which is a few more than I've done. And David, welcome, and we're happy to have you here.
Well, thanks very much. I appreciate the invitation. So I'm going to be relying, Steve, on you, I believe, or someone to click the slides forward. And let me just say, by way of introduction, that my practice is, as Steve said, in the fields of both mediation and collaborative law. And what I've seen over the years is that we are using mediation more in collaborative cases, and we're using collaborative principles more in the mediation cases. And these two processes, which began as, well, I'll talk about this in a minute, but they began in some ways as rivals, are now recognizing how much common ground they have. Steve, if you could advance the slide, or whoever's in charge. This cartoon from the New Yorker captures my feeling about trainings, including webinars. And so I encourage you to type into the chat box if you have a question or comment or reaction along the way. Those 2 people out there on the precipice, Steve and Frances, and I'm the one with the spear talking right now, but just speak up if your needs aren't being met. We'll see what we can do about it.
That is certainly how I felt the time I collaborated. Like I was falling off.
Yeah.
Thank you.
So, let's go on to the next slide, which will provide an overview of where we're going. You can click along to get us all the way to the bottom. I want everyone to see the topics that I'm going to cover here, and I hope we'll have time at the end of my presentation for some Q&A. But as I said, feel free to raise a question or share a comment along the way. So we're going to talk about this idea of whether collaborative practice and mediation can play well together, and then talk a little bit about the difference between mediators and coaches. We're very accustomed nowadays in the collaborative world to use coaches, and talk a little bit about what that concept entails. And then I'll talk about some case examples and the idea of why bring mediation into a collaborative case. And likewise, if you're mediating, why use collaborative practice? Talk a little bit about how to pick, a mediator. And then there's some technical questions about if you're combining processes in some way, what are the rules? What rules apply? And I'm going to try an experiment before we go on to the next, or as we go on to the next slide. If people could type into the chat box simply whether you are a mediator, a collaborative practitioner, or both, then we'll have a sense of who's on the line without having to get everyone's voice into the mix here, which is hard with the webinar. So I'm seeing some images up on the chat box of mediator in family law, mediator, neither, aspiring to both. Let's see what else we've got. Mediator. Okay, we'll keep those inputs coming, so we'll have a sense of who's on the line. And in the meantime, I'll press on. So when I first got involved with collaborative law, when the field was relatively new, some of the people who were teaching and training collaborative law were doing so in a way that was very critical of mediation. And some of you may know the history of collaborative law, and you may know that the person who first came up with the idea, Stu Webb, had been disgruntled with litigation, got trained as a mediator, and then he found that mediation was, he was uncomfortable with it because when he was meeting with the two parties, he felt like they didn't have real-time legal advice. So that's when he came up with the idea, well, let's have the lawyers in the room. Maybe we don't need a mediator if the lawyers agree that they're in the case only for negotiation. So thus, collaborative law was born in the year 1990 in Minnesota, and it has spread around the country. But as it was spreading, as I said, people were saying, well, mediation is a flawed process. Meanwhile, the mediators, I think some of them feeling threatened by collaborative law, wondering whether collaborative law was going to eat the mediators, the mediation movement's lunch, described collaborative law as an oxymoron, that lawyers were sort of like wolf in sheep's clothing. We'd entice the clients to come in and with a lot of wonderful aspirations about collaboration, but when it came right down to it, lawyers are really self-motivated, and our instincts are basically competitive. So I found this very troubling since I was doing both mediation and collaborative law, and I didn't think that either of these critiques was accurate. I'm very pleased to see that nowadays the rhetoric at the mediation conferences and the collaborative law conferences is less critical. And I'm seeing more and more conferences, workshops that are jointly sponsored by mediation groups and collaborative law groups. By the way, it might be wise for me just to hit the pause button here and ask Steve or others if you would like to comment as to whether in Alabama there's been any of this feeling of competition.
You know, I haven't sensed that there was competition, but I do think that mediation has been practiced in Alabama in a much more positional bargaining method. And so it it set the two methods apart more. You had an interest-based sort of focused process and a positional bargaining negotiation style process.
Yeah.
I never criticized mediation though. I mean, I just, so that's interesting. This history that you're talking about, I think I was oblivious to.
Yeah. Well, it's interesting because the people who were saying these things were not the rank and file mediators and collaborative lawyers. Most of the people that I met over the years in the collaborative law movement worked in both mediation and collaborative law, and they were, they didn't see an inherent conflict. Where I was hearing this was at the leadership levels of the organizations, where I think people were trying to stake out territory for their respective processes. And as I said, this is now abated, and I'm glad to hear that Alabama has not been infected with this competitive attitude, because really mediation and collaborative practice are siblings. We've sprung from the same soil, so to speak, of disgruntlement with litigation as too costly, too adversarial, too time-consuming, and both of these methods are better ways. Let's go to the next slide and talk a little bit about the question of mediators and coaches. And if you could click right through till we get to the bottom of this slide, I appreciate it. So the first point about mediators and coaches is about communication management. So in the collaborative movement, there came a time when people recognized that the original Stu Webb model, which was 2 lawyers, 2 clients, and that's it, and a participation agreement that said the lawyers are in it only for negotiation. Stu would, to this day, describe that as the essential ingredients of collaborative practice. Everything else is commentary. I think that there are some people in the field who have a different view. Hold on just a second. And believe that some of the other elements are very important also. But whether they're essential or non-essential, I think what's happened is that more and more people are recognizing that 2 lawyers and 2 clients may work just fine in a simple, straightforward case where the emotional issues are not too intense. But if you've got complexity or you have high levels of conflict, then having a coach is a good idea to manage the communications. The second, mediators do more than just manage communications. Mediators tend to have at least some degree of subject matter expertise, even if it's only as in law. But sometimes nowadays mediation, there's more specialization by type of case, whether it's an employment mediator or family mediator, etc. Generally, the coaches, who are often mental health professionals, simply want to deal with the emotional issues, not the subject matter issues. In my view, you try to find the right person for the case. Do you need someone who's psychologically oriented, or do you need someone who has strong subject matter expertise? Maybe you need both. A third way in which one can compare and contrast the role of coaches in the collaborative process versus bringing a mediator into a collaborative process is shuttle diplomacy. In my experience, coaches are somewhat uncomfortable with the idea of being shuttle diplomats. Kissinger, of course, was the first one to, I don't know if he coined it or it was the media that described his flying back and forth in the Middle East as shuttle diplomacy. Here we see John Kerry following in Kissinger's footsteps and having separate meetings. I have found that shuttle diplomacy, or caucusing as we call it, is extremely useful in commercial mediation, but I think it's overutilized there. I think we often sacrifice the value of joint sessions in those commercial cases. And I think shuttle diplomacy is rarely used in family cases, at least in my experience and my discussions with mediators around the country. And I think shuttle diplomacy is underutilized in family cases. I think there are opportunities where we could use it more, and it would be very worthwhile. In the collaborative process, the question is, if you're going to bring in a third-party neutral, call the person a mediator or a coach or whatever, is that person going to only participate in joint meetings, or will there be some shuttle diplomacy? In my experience, there's often significant value in having coaches or mediators caucus and do some shuttle diplomacy. I'll be interested in a bit, or now if you'd like, in hearing about your experiences with that as a facet of this process. So let's move on to the next slide. And with this one, you can click through it. I just want to share with you a couple of case examples of where I thought the neutrals, we called them, well, in the first case that I'll describe, which is a high conflict couple, it was a mental health professional, but she also does mediation, and she's really good at it. And in this case, it was a divorce case. Both of these were divorce cases. In the high conflict couple, the two parties literally could not stand to be in the same room together. They just pushed each other's buttons mercilessly to the point where conversation really was unmanageable. And despite having a very skillful coach, they would start pointing the finger of blame at each other. And as we all know, that's usually just escalates the hostilities. And we're having a really hard time de-escalating them. The coach then met with each side, and that was helpful. But what we came up with is a methodology that seemed to work rather well. The other lawyer and I got along extremely well. I represented the husband in this case, and the other lawyer represented the wife. We liked each other. We liked the coach. And so the three of us decided that we would have the clients sit in separate rooms, and the three of us would shuttle back and forth to hear what each had to say, explore interests, explore options, do some problem solving, let them vent in the way they needed to vent so that they could let some steam out of the kettle. And that enabled us to resolve the case. It was a little unconventional, but I think perhaps the theme of this webinar, at least from my standpoint, is sometimes we can and should think outside the box of process to fit the form to the fuss. That's a quote from Professor Frank Sander, who died this past year. And I think that there is a tendency in the collaborative law movement, maybe even a little bit in some parts of the mediation movement, a tendency toward orthodoxy. When collaborative law, was first developed, first taught, the idea of having two lawyers and a coach march back and forth between two rooms and keep the parties apart would have been considered heresy. The whole point of collaborative law is to have the parties in the room, to have them communicating with each other, developing higher levels of understanding, and taking the ownership of the case to solve the problems at hand. Well, that's a very idealistic and wonderful model, and it does work that way in some cases. But in some cases, if parties have to stay in the same room, the process is going to come to an end. At least that's been my experience, and it certainly was in this high conflict couples case. The reluctant banker was my client, again, representing the husband. It was a heterosexual marriage, and he was very unhappy with the collaborative process. The only reason he stayed with it is because litigation seemed a lot worse. And there were some, I mentioned the fact that he was a banker because there were some very complex financial issues. And we had a financial neutral. I don't think she would mind my mentioning that her name is Susan Miller. She's not only a CPA and a financial planner, but she's also a mediator. And so in this case, we brought her in as a financial neutral to help the parties communicate better and the complexities of the parties' finances. And we had a coach because there were parenting issues. And our coach was a psychologist and a child specialist, wearing both hats. And in that case, the two professionals shuttled back and forth while I stayed with my client and the wife's lawyer stayed with her client. And so we used the shuttle diplomacy process. But the reason I mention this case is because in this case, the psychologist and the CPA, who are neutral, were willing to get involved in the substance of the case and to help generate options and to bring proposals, concrete proposals from one room to the next. So again, this is not the conventional, ordinary way to do collaborative, but it underscores the way in which mediation techniques can add value in the collaborative setting and how a collaborative commitment on the part of the lawyers can make mediation more successful. So I just want to hit the pause button for a minute before we go to the next slide, just to see if there are any questions or comments or reactions to what I've said so far. And you can put them in the chat bar, or you can unmute your phone and speak up, whichever you prefer.
David, this is Steve. How did you decide, along with your colleagues, how to that you were going to utilize shuttle diplomacy in those two cases, and how far along in the process did it take you?
Well, in both of these cases, we tried to do the work in the ordinary way, which is to say, let's stay in the room together, roll up our sleeves. And in both cases, we had a coach right from the beginning. It was pretty clear in both cases that the emotions were running high. But we didn't decide to do shuttle diplomacy until it was clear that meeting together was unproductive. So I guess I would say it's very context specific. I can't really give you kind of a general guideline of when to do it and when not to do it, sort of like you know it when you see it. Does that make sense?
Sure, thanks.
Any other comments or questions before we press on? If you have some along the way, please feel free to type them into the chat bar. Let's go to the next slide. And why use mediation? So if you want to click all the way through to the bottom of the slide, that's fine. So how do mediators add value in a setting where you've got two parties, two lawyers, and maybe a coach? Under what circumstances would you want to empower the coach to take on a more active, mediative kind of role, or bring in someone whose specialty is mediation? And I am identifying here three ways that I see mediators adding value. The first, reframing, is something that coaches do, mediators do, basically a way of allowing people to feel heard, both the words and the music, to really get the emotional valence, if you will, of what they're trying to communicate. Because until people feel heard, they won't listen. So that's an important part of what we do. And of course, if it's a collaborative case, the lawyer who's sitting, who represents the other party, can play a very important role of being an active listener, of reframing and letting the party know that he or she has been heard and understood. And that's a very powerful intervention. Sometimes a party doesn't want to hear it from the other lawyer, feels that the other lawyer is being, maybe patronizing or inauthentic. So that it's a tricky maneuver. But if the lawyer for the other party can pull it off and reframe in an authentic way, I think it's a very valuable tool. But the value of a coach or mediator, in situations where there's a lot of validation that's needed, super important. But these other two points, B and C, are, I think, where there's a real value add for bringing a mediator into a collaborative process. And B is this problem of what we call adverse selection, which basically means the parties really, there's a deal that could be made. They have overlapping zones of possible agreement, but it's hard to navigate there because each side is afraid that their cooperation won't be reciprocated. Those are the situations where mediators can add value because they can listen confidentially to what each side is willing to do and see if there is a zone of possible agreement, or maybe do some reality testing with each side to maybe expand or create the zone of possible agreement and overcome this problem of people, adverse selection, people not settling when actually there was enough authority and flexibility in the room to do the job. They were just afraid that their cooperation would be exploited if they were candid about it. The third point, the mediator's proposal, is something that can't be done if everybody stays in the room together the whole time. It requires shuttle diplomacy. And let me just explain quickly the term reactive evaluation. I suspect that people on this webinar probably heard that expression and know what it is, but if there's anyone for whom that's not a familiar term, reactive evaluation means that we sometimes discount the value of a proposal made by someone whose interests are adverse or perceived to be adverse to us because we think there's a hidden agenda. And if someone proposes 100,000 and we are actually would have been quite content to accept 100,000, their offer of 100,000 makes us think that there's more there. So the question is, how do we get to yes when people are very suspicious of each other's proposals? And one way to do that is to have options generated by a mediator or a coach. And more specifically, the idea of a mediator's proposal. Not every mediator is comfortable using this technique, but I find that I'm using it more and more. In my commercial cases, I would say a majority involve, by the end of the day, some kind of mediator's proposal if the parties are at an impasse or they're nearing an impasse. And the basic ground rules are very simple, but very important to do it, in my opinion, in this way. The mediator makes a proposal, same proposal to both sides, and that can be done in a joint session, but in my experience, it works much better to make the proposal in separate rooms so that the parties are not inclined to respond in the moment by facial expression, body language, or just blurting out, well, you will never agree to that, or something like that. So better to make your mediator's proposal in 2 separate rooms. And then here's the key ingredient. This is the secret sauce, in my opinion. The mediator gets a yes or a no from each side, but it's confidential, yes or no. And the mediator reports back to the parties nothing about what he or she heard unless it's 2 yeses. If there are 2 yeses, the mediator says, okay, the mediator's proposal is accepted, we're done. But any other combination, the mediator just says, we didn't achieve a settlement. Now, that confidential listening on the part of the mediator is crucial, because what it does is it gives each side the courage to say yes to the proposal, knowing that the other side will never know that they said yes unless the other side also said yes. And what happens is it creates an information asymmetry. The party that says yes now is going to have more information than the other side, because if the other side says yes, well, there's a settlement. But if they say no, the party that says yes now knows where the other side is at. Now, the purpose of this is not to create an information asymmetry, not at all. The goal is to give each side the courage and the safety in saying yes without fearing that their flexibility will be exploited. And I've found that when a case is truly narrowing to the point of an impasse, if the parties want a mediator's proposal, and I explain the ground rules and so forth, about 80% of the time, the mediator's proposal settles the case. And in the 20% of cases where it doesn't work, about half of those settle quickly because the one party said yes and decides to communicate that to the other side, and then they split the difference, or they come together in some other manner. So I highly recommend this technique. It can only be done if you have a neutral. It can only be done if you have a neutral who is willing to venture a proposal. And I want to say one further thing before we leave this topic. Some people use mediators to do a little bit of case evaluation, asking the mediator, give us some feedback here. What do you think is going to happen if we go to court? Now, when I'm wearing the mediator's hat, I usually decline to give that evaluative feedback unless both sides want it. And I'm finding these days more and more the lawyers are not asking for me to do that. They feel like they know the case better than I do, and they most assuredly do. They've been living with the case for a year or 2 or 3, and I'm the new kid on the block. But occasionally they do ask for that. And so when you do a mediator's proposal, someone might ask, well, what's the difference between that and case evaluation? And there's a very important difference. Case evaluation is a prediction of what a court will do. A mediator's proposal is a prediction of what the parties might be willing to do. In other words, the purpose of the mediator's proposal is to try to find the sweet spot, or the center of the dartboard. When you throw your dart, the center where the case could settle, where there's if there's a zone of possible agreement, that you've kind of nailed it. And so it's not saying that one side's case is stronger than the others. Simply, I think this is a place where the parties might be willing to meet and might decide that they're better off settling at this number rather than rolling the dice and going to trial. So again, I want to hit the pause button and ask Francis, Steve, if you have any comments or reactions to what I've said so far. And if anyone on the line wants to type something into the chat bar, question or comment, we can do that. Thoughts, reactions?
Please don't construe that as disinterest. I'm fascinated, but I don't have a comment.
Okay, Steve.
Well, I think that, David, when you're talking about using a mediator's proposal, you're talking about using it at the end of a process which is a facilitative mediation, not an evaluative mediation. And in Alabama, especially in civil cases, there's a lot of evaluative mediation being done, and probably, I suspect, more than facilitative. So talk a little bit about, if you can, if this question makes sense, whether a mediator's proposal is usually a part of an evaluative mediation or not.
Yeah, I guess my view is that mediators range along a spectrum of some who are highly facilitative, very uncomfortable being evaluative, and all the way to the other end, where we often encounter a lot of retired judges who've been, just have a long career of experience of seeing how, juries decide cases or how they're decided in bench trials. And they feel, and it's very understandable, that they're adding value by being very direct about what they think about the arguments advanced on each side. And then there are people like me who start cases at the facilitative end of the scale, and then if the parties are kind of stuck and things are not moving, I'm going to be a little bit more evaluative, a little more directive, till I might wind up all the way at the other end of the scale. So for me, it's very case specific, and I'm describing here how I handle both family and non-family cases. But Steve, I think you're right that the idea of a mediator's proposal might be used more by the facilitative, mediators. But I would suggest that even for mediators who are evaluative in their approach, I would encourage them to maybe dial it back a little bit at first to see if maybe the parties can navigate toward a resolution, on their own, and to use a mediator's proposal in appropriate cases if the parties want it, because it sometimes overcomes this problem of not wanting to be told what to do. One of the problems with evaluative mediation is that it can cause some resistance. But if you lay out in a mediator's proposal some of the reasons why that proposal might actually work well for party A or work well for party B, talking in separate rooms with them, I think it gives them a little bit more of a sense that they've embraced something. And people are more likely to comply with agreements that they have voluntarily embraced, and have less residual hard feeling and regret, which, as we know, the residual hard feeling and regret can sometimes lead to parties undermining agreements in various ways. So our job is not just to get a signed settlement agreement, but one that the parties, can walk away from and say, yeah, this is better than the alternative. I'm really okay with this. That's an added value if we can do it. So none of these processes, by the way, are mutually exclusive. I've had cases where I did a case evaluation and it didn't result in settlement, and then later the parties asked me to do a mediator's proposal, and it didn't result in settlement. But then one side said, well, here's what we told the mediator. The other side said, okay, I guess we're not that far apart, and they got the deal done. So these are all tools in the mediator's toolbox, and we pull them out as needed if the context suggests they add value. Should we press on? Let's go to the next slide. So on the next slide, I'm laying out some points about why how does collaborative law add value? It seems to me that if you are in a mediation, particularly in the family area, someone comes to you and says, we'd like to use you as a mediator and we need to hire lawyers. I always suggest that I give out the roster for the Collaborative Law Council here in Massachusetts. I also give out the roster of the mediation group and encourage them to hire as lawyers people who are collaboratively oriented and mediation friendly. And the reason is that if they hire lawyers who are not mediation friendly and who are not collaborative in their orientation, there is an incentive to litigate. There's an economic incentive on the part of the lawyers. But if they hire collaborative lawyers who are only in it for negotiation, then there's a disincentive both for the parties to litigate, and the lawyers aren't going to do it. Now, here in Massachusetts, we have a bunch of collaborative lawyers who no longer go to court. I am now one of them. For years, I did both, but now I don't take on any new cases for litigation. But in around the country, in my experience, most lawyers who do collaborative practice also go to court still. But even those lawyers, if they sign on to a mediation case, they could agree that in this particular case, they're in it as collaborative law attorneys. They're in it to support the mediation. And then that creates a disincentive for the parties to go off to court. I think that using a collaborative protocol and using collaboratively trained lawyers, this is point B, definitely enhances negotiations. It's always helpful to have three professional problem solvers in the room. And so I think, and whether the lawyers are, off in the wings or on stage in the mediations, in both scenarios, and as we all know, in family mediation, often the lawyers don't come to the mediation sessions, but in my experience, they sometimes do if it's a tough, complicated, maybe financially driven case.
I don't think Alabama has gotten to the point where we let our clients go to mediation without us.
You say that is starting to happen?
No, I don't think we're there yet.
Okay.
Yeah, only collaborative lawyers, I think, would have that mindset or orientation, and there aren't enough of us to really be influencing the full direction of the model. But that, so I think that concept is probably foreign to most listeners to this webinar, just so you know.
Okay. Well, thank you. Thank you for mentioning that. And I'll just say that in Massachusetts and in other parts of the country, it is sometimes the predominant mode of divorce mediation that the parties meet with the mediator without the lawyers present. But and that's the case here. But as I said, if it's a very complicated legal situation, complicated financial situation, then the lawyers are certainly welcome to attend. It adds some cost. But I find that when child-related issues, I don't see the lawyers adding value as much as when we're talking about legal and financial questions. But in any event, the third point is about how collaboratively trained lawyers have a very different orientation to negotiation. I think litigators, when they sit down to negotiate, their instinct is to think, okay, how many of the 10 points that we have to reach agreement on in order to be done with this case, how many of those 10 points can we win? And Francis, I hear you chuckling because I guess we've been trained the same way. This is how law school trains us. This is how the litigation arena trains us, and the collaborative process, the collaborative training, teaches us that there are ways to expand the pie. And it's a completely different mindset. So that's why I think even though mediation is a good process in and of itself, there's a real value add if you bring in collaborative professionals. Let's go to the next slide and talk about, if you're in a collaborative case, how are you going to pick a mediator? And my feeling is, as I said in the slide, it's more art than science. You're looking for somebody who's a good fit stylistically. Do they have a lot of experience in the particular area, whether it's the family or otherwise? You know, do they have a bedside manner that's going to work well? And sometimes there are identity issues. For example, I've mediated cases involving race discrimination where, because I'm white, it was very helpful to bring in a co-mediator who is non-white. I think that some divorce cases, the gender of the mediator matters. So if it's a heterosexual marriage headed for divorce, will the wife feel more comfortable with a mediator who's a woman versus a mediator who's a man? And likewise with the husband, is he going to feel more comfortable with a man or woman as the mediator? Sometimes co-mediation helps. My experience has been, even if there's some initial concern about gender or race or other factors, once the parties actually sit down and talk with the mediator, that concern tends to evaporate. But in some cases, it doesn't. And in some cases, the parties have enough resources and would get added value from having a co-mediator. I sometimes, in family cases, have as a co-mediator a psychologist, because my training is as a lawyer. And I think that's a good combination. Obviously, cost and experience and references are factors. And one of the things that I think we should try to avoid is always going with the same the usual suspects. And I think we have a duty to diversify our field, our professional field, as much as possible, and bring in people who have been underrepresented in law and in mediation. And so I encourage all of us, when we're in a position to influence choices, to make sure that we're offering people a range of options, people from different backgrounds. Let's go on to the next slide. And in this one, I've only changed the cartoon. And actually, if you can go back one slide, I'd appreciate it. Yeah, so I love this New Yorker cartoon where the bartender is the mediator. And it sort of illustrates the point that lots of people can be mediators. They come in lots of different backgrounds. Let's go on to the next slide, number 7, and talk very briefly about the rules. As lawyers, we obviously have to pay close attention to not only the ethics, but also to what extent are these very personal matters that are being discussed going to be kept confidential? To what extent will they be privileged? And I'm not going to try to articulate how each of these sets of rules and each of these sources of law intersect with each other, because your mileage may vary in Alabama as compared to our mileage in Massachusetts or, you know, in some other state. But suffice it to say that we need to look at, first of all, is there a statute that governs mediation? Is there a statute that governs collaborative law in the state where you are engaging in this process? Because if you have collaborative professionals and you also have a mediator, there may be overlapping sources of legal authority, and the statutes may differ in terms of what exceptions there are to confidentiality and privilege. With regard to common law, we create contractual obligations and rights through the agreement to mediate in mediation or the collaborative participation agreement. And in some cases I've been involved in where we're doing both, we have two agreements. And so we have to make sure that those two agreements are consistent with each other and consistent with the statutes that govern these processes. And finally, if we're bringing in professionals from various backgrounds, then we've got several ethical codes to think about. In a collaborative case, we have the ethical standards of the International Academy of Collaborative Professionals. In mediation, we have the ABA family law section standards for ethical practice of family mediation. There may be state-specific codes for mediators, and then the professionals have their own ethical codes. Lawyers have to adhere to the rules of professional conduct. If they're therapists or financial professionals, they have their own ethics. So at the very beginning of the process, or when you add a new professional, it's a good idea to just take a step back and say, okay, what are the rules that govern what we can do, what we must do, and what we must not do? Because it gets a little complicated with each professional discipline that's added. So we've got 6 minutes left before this webinar is going to end. If you go to the next slide, you'll see that what I would like to do right now is open the floor for questions, comments, and reactions.
And at this time, I will unmute all the phones.
Thank you.
And so if you have a question for David or Stephen or Francis, if you'll please state your name and your question. Thank you.
I also invite disagreement.
That's a great slide.
Was there anything that I said that struck you as surprising, not what you expected to hear, or something that just wouldn't work in your professional setting?
This is Ronald Kim. I was wondering if when you have co-mediators, do you reduce your hourly rates?
Good question. And the answer is sometimes. I've done it in cases where the parties had limited resources, but I've also used co-mediation in settings where the parties had resources that were quite ample and there was no need to do that. But as a marketing matter, I think if you encounter price resistance, I think the co-mediators need to have a candid conversation about whether they want to offer a blended rate and how they want to divide the rate. And if the co-mediators, one is a lawyer and one isn't, you have to be careful that you're not sharing fees. The parties will pay you separately.
Okay, thank you.
David, this is Steve. I have a more general question about the use of collaborative law around the country and also in around Boston. How much are you seeing collaborative law now used to resolve civil disputes in the Boston area, and also what's your knowledge about that with regard to the whole country?
It's a great question, and it's one that we in the collaborative movement have been scratching our heads about for years, because collaborative law has taken off like the proverbial rocket in the area of family law. It's widely used throughout the United States and in a number of other countries. Here in the United States, commercial matters very seldom wind up in a collaborative process, and I think that's in part because in a non-family case, there's usually one or more of the parties have ongoing relationships with their lawyers, whether it's an insurance company or it's a business. or to employer, manufacturer. These are repeat players, and they don't want to fire their lawyers. They want to keep their lawyers. So it's an unusual case where both the clients and the lawyers want to use collaboration in a business setting. However, there are parts of the world where there's been more traction. And for example, I believe it's Saskatchewan, which is a fairly sparsely populated province, where I think the last time I heard there was something like 900 lawyers in the province, and I think something like a sixth of them have been trained in collaborative law. And in many of the smaller towns and smaller cities of Saskatchewan, there's a critical mass of lawyers who've been trained in collaborative law and handle divorces that way. And in those areas, geographic areas, when those general practitioner lawyers get a business case, they will often decide to sign a collaborative law protocol or participation agreement. So that's one way in which collaborative law has gotten traction in the world of business. There's one other aspect that I want to mention before leaving this question. That is that I think it's worthwhile bringing in business lawyers into the collaborative movement, because even if their clients don't want to sign a collaborative participation agreement, creating a critical mass of business lawyers who have this training can really change the way business conflicts, non-family conflicts get resolved. So I don't know, Steve, if that's a helpful response or if you want to respond further.
No, it is helpful. Thanks.
Well, and I sort of think that's the point of this and the next webinar, in my view, is just to help people understand that the collaborative law training has so many applications, even when not directly applied to the practice of collaborative. As a lawyer, there are so many benefits to this education and training, and the applicability of it to your practice becomes amazingly pervasive the more you know and the more you apply the skills.
Let me offer a final hopeful thought here. Bob Mnookin and Ron Gilson wrote an article some years ago called Disputing Through Agents. And in that article, they predicted that lawyers who develop a reputation for being able to resolve cases would actually be able to increase their fees, their hourly rate, because they are adding value for their clients. Now, I know one lawyer here in Massachusetts who actually charges more per hour for her collaborative cases because she feels like she is adding that value. I don't do that, charge the same rate for everybody. But Mnookin and Gilson are theorists. They're both academics. And what they're pointing to is that we do actually add value when we learn how to resolve cases amicably, quickly, and in ways that maximize the welfare of the parties, win-win solutions, creative problem solving. And that's what this movement is all about. Whether you have a participation agreement or not, we're all learning from each other how to do this work better. And I really appreciate the invitation to come here today and talk with you about this and to expand my connections with people who are sharing in this important work. So thank you very much.
Thank you.
Thanks, David.
And this is Eileen Harris with the Alabama Center for Dispute Resolution. I very much appreciate you all for joining us today. Thank you, Stephen, Francis, and David. This has been incredibly informative and I think an exceptional program, so thank you. I invite everyone to visit the Alabama Center for Dispute Resolution's website and Facebook pages for more training opportunities. Our next webinar is Friday, March 1st, and we hope that you'll join us. Please remember to complete your program evaluation on SurveyMonkey. The code to enter on the survey is ALA200. That's ALA200. Alabama is celebrating our 200th bicentennial of statehood. And the recording of today's webinar will be posted on the center's website. Thank you all again for attending, and this will conclude our webinar.